Hi there, this is Val Heminger, and I'm the owner of Pathway Legal and one of its founders. In this video, I'm going to talk about child support. Okay, so here's the thing. Canadians find supporting children a very, very important thing. In fact, we would almost consider it to be non-negotiable. We have the Federal Child Support Guidelines. Unlike in the Pirates of Caribbean, when they had guidelines, they were really like guidelines. Well, our guidelines aren't really guidelines at all. They are rules. So there's two components to the child support. There's table support or guideline support, and then there's something called Section 7 expenses. Okay. Table support, here's how it is. You look at what the parent's income is, you look at how many kids there are, you go down the table, go boom, there's your number. So the whole idea behind that is that parents who earn $50,000 a year probably spend less on their kids than a parent who earns $200,000 a year. So you can see the distinction there. So it's back in the olden days, prior to 1996, when the guidelines came out, there would be all these things about budgets and running shoes and jackets and lessons and all kinds of stuff. And now it's like, nope, you make this much, that's what you pay. If the children are in one parent's care more than 60% of the time. But hey, what about shared care situations? So a lot of the time people think, well, if I share my kid equally with the other parent, then we don't have to pay child support. Well, that's not necessarily the case, because guess what? If you have one parent who makes $50,000 a year, another parent making $200,000 a year, a lot of the time, unless the $50,000 a year parent is really well set up, a lot of the time there will be a set-off amount where even though the parents are in shared parenting, the higher income earning parent is still going to end up paying a bit of money to the lower income earning parent. So that's when we have a shared parenting situation. Sometimes we have a split parenting situation. What? Okay, that is when you have one kid living with one parent and another kid living with another parent, and they kind of like each pay the other parent a differing amount, which ends up being like a set-off in a certain amount of money. The nice thing about the Federal Child Support Guidelines is that they literally make it like so easy to determine child support. But then as a lawyer and as a person who may be entitled to support or maybe having to pay support, child support, the thing is that it's the right of the child. In fact, in order to get a divorce, if you're married, you will not get that divorce if the court isn't satisfied that your child's needs are looked after, that you've considered the Federal Child Support Guidelines. Sometimes a parent, they make more money than what Revenue Canada thinks they make. I think about a certain situation where the dad actually had wicked write-offs because he was self-employed, but his write-offs were huge, and CRA was fine with that, but the mom's like, seriously? Really? I know you do business when you travel to Europe, but really, do you need to stay at the nicest place, blah, blah, blah. So the thing is what these parents did was they said, okay, Dad, you write off as much as you can legally do, and that's between you and Revenue Canada. But as far as Mom is concerned, you can only write off this much money. So that was a way to ensure that Dad's income was kind of reasonable for his obligation to pay support. As an example I often use is like sometimes people need to pay for a lease payment for a vehicle because they have to look good, to see clients and that kind of stuff. But maybe they could do just as well in an Acura as opposed to, a Beamer or something else, or a Jaguar or something like that, right? So again, that could be acceptable, that expense, to CRA, but not necessarily acceptable for your child support obligation. So we call that imputing income to someone. So when your Revenue Canada document and income looks like one way, but then you pay a different amount based upon a different kind of income. Then let's talk about special expenses. So special expenses are indeed special. So if you look at Section 7 of the Federal Child Support Guidelines, when you're buying your child a pair of running shoes, that is an expense and it's expensive, but that's not a special expense. What are special expenses? Childcare, a nanny, a babysitter. Now again, not because you want to go and hang out with your friends, but if you need that care because you're working or you're in school or because of an illness or disability. Okay, so that's a special expense. Another special expense is health-related costs for kids. So sometimes what will happen is parents might have a extended benefit plan, but then there's an extra premium that has to be paid. Well, that's a special expense. Or maybe the child needs braces. That's a special expense. Other educational related expenses for the child. Maybe the child goes to Sylvan Learning Center. Maybe they need tutoring. So all of those are legitimate special expenses. Private school, often that is considered, well, almost always it's considered a special expense, but again, the family, has to have had the pattern of the child going to private school prior to separation. So there's all kinds of ways that parents don't necessarily agree as to what is and what is not a special expense. Some special expenses have a question mark. For example, hockey. Now, we know that kids who play hockey, the fees are huge, the equipment's huge. It's a lifestyle change for the parents because they have to get up so early sometimes to let their kids hit the ice on time for practices and all of that. So the thing is that that's a real priority for some parents. And for some, maybe the other parents like, what? No, I don't want to get up at 4 a.m. Forget it. Wait, how much? Forget it. So that's where the question mark is. So sometimes it depends on the situation relating to the child. I had a case once where it was determined that the daughter had a special expense relating to dance. Now, dance isn't necessarily a special expense. She was in high-end dance. That was nice because it meant that she was consumed with and exploring her dance, which is wonderful for her. But the thing is that what the mom did was she actually submitted a letter from the doctor that said, you know what, this child has big problems with anxiety, and you know what she needs? She needs to dance because that is such a helpful thing. So a provincial court judge said, yeah, okay, we're going to call that a special expense now. So you can see why there's some question marks around some of the stuff in terms of what is and what is not a special expense. Post-secondary costs, that's tuition, books. And again, it becomes a very, very big question because how much is the student, how much is the child contributing? How long is that special expense going to last for? Every single case is completely different. We want to apply what they're doing for summer work. What scholarships do they have? What bursaries do they have? University is expensive, and of course the courts understand that. If parents are separated, the law says that you have to contribute to your child's university education if they're still living at home, etc. Okay? Yet, if parents are still together, there's no law saying you have to pay for their school. With respect to extracurricular activities, that may or may not be a special expense. If you want an appointment because you need to know about special expenses, you need to get some great legal advice about how to help you, click right down here and we will set up an appointment for you. Or you could do the wild thing and call us 250-220-8686.